2, 1 second.
And you met
We are
Ron.
live.
Oh yay, oh yay, oh yay. The Honorable Court of Appeals for the 7th District of Texas is now in session.
Thank you for joining us to the afternoon settings on Wednesday, May 13th, 2020, the 7th Court of Appeals. We appreciate counsel agreeing to appear by Zoom video given these circumstances. I think it's probably a way to facilitate our consideration of the case and allow us to come to a decision more promptly. Before I actually call a docket, let me remind you of something that we've encountered in some of our earlier videos today. It looks like both of you are sitting, which is fine, but if you move forward or back and forth, sometimes you will go out of your camera range, and then we'll end up seeing a forehead or a cheek or something like that, and that's about it. So if you can keep conscious of where you are there, that would be great. And also, this is being broadcast over YouTube, so people in Mars are able to see you too. So with that said, we will go on and call the docket. The first case we have for this afternoon is 07-19-00213-CV, Dulce Restaurants, L.L.C. versus Texas Workforce Commission. And Mr. Siegel, you're representing the appellants. I'm assuming you're ready.
Yes, Your Honor.
Thank you. And Mr. Kennedy, you're representing the Attorney General, and I'm assuming you're ready.
Yes, Your Honor.
Have any of you argued in front of us before?
Mr. Siegel, I've argued in front of the court. I don't remember if it was the same panel, but it was the Verizon case probably 5-6 years ago.
I think
And I have not.
I'm sorry? Go on,
I'm
Mr.
sorry.
Kennedy.
I was just going to say I have not argued before the 7th Court before.
Sometimes we have a tendency to ask questions, and Mr. Siegel, you argued before, you probably realize that. Answer the questions the best you can, short, sweet, and then you can, after that short, sweet answer, you can expand on it. But if you could answer them, that would be great. And often in answering those questions, we play devil's advocate. So do not read more into our questions than us just asking questions. Don't think we're leaning one way or the other based on our questions. With that said, we will turn to the arguments, and Mr. Siegel, you got the floor.
Thank you. May it please the court. This is a Texas Workforce Commission appeal, and it involves a fairly routine garden variety arm's length purchase of 3 donut stores by my client Dulce from a company called North Texas Donuts that I'll just refer to as North Texas. And this is the type of transaction anyone involved in this argument, whether it be a justice or myself or Mr. Kennedy, if we were retired and wanted to buy 3 donut stores, we would go buy them from a company that already owned donut stores. After the purchase, we would of course have to enter into a new franchise agreement with the franchisor, and maybe it would be a McDonald's or any other franchise. And the Texas Workforce Commission takes the position that Labor Code Section 204.083, which is referred to as the anti-SUTA dumping statute, applies. It doesn't apply. The statute is designed to deal with a situation where an employer with a high or bad unemployment insurance rating goes through a corporate reorganization in an effort to get rid of that bad rating. And that's what the statute.
Can I hold you for a second, Ms. Siegel? Judge Pirtle, can you hit the timer, please?
Mea culpa. I'm so sorry.
Todo está bien.
Let me, yeah.
Thanks, sir. I'm sorry, Ms. Siegel.
So the statute is designed to deal with a corporate reorganization that companies were engaging in to avoid bad unemployment insurance ratings. And I think we can all envision what that would involve. The owner of the donut shop, for example, sets up a subsidiary or sells it to his mother-in-law. and really the control and management is the same, but the transaction is intended to avoid a bad unemployment insurance rating. Now, this transaction here could be nothing further from that. And this was a summary judgment ruling in which the trial court said that, I believe, based upon the franchise agreements, the fact that there were franchise agreements, the franchise agreements somehow created a continued management or control of the buyer, Dulce, by the selling entity, North Texas Donuts. So let me go to what I think is the issue, sort of framing this legally. Did the predecessor employing unit, which is North Texas, continue to direct the internal affairs or conduct of the organization, trade, or business that was sold, Dulce? And the answer to that is no. Now, if you read through the briefs, the only piece of evidence, the only shred of evidence that the TWC grasps onto is the fact that in the purchase and sale agreement between the parties, there's a reference to a franchise agreement that's going to have to be entered into and followed by Dulce. The fact that the buyer represents and warrants that it's going to follow a franchise agreement, that somehow creates a continuing management and control, which is just defies reality, I would argue. Many times an acquisition agreement is going to have reps and warranties. The buyer will follow all state and local regulations. The buyer will follow franchise agreements. There's a garden variety of reps and warranties that go into agreements, and any of us who have had experience as transactional attorneys would understand why those things are there. However, the reality is that after the closing of this transaction, according to the affidavits, North Texas had absolutely nothing to do with Dulce's running of those donut shops. Prior to the closing, North Texas ran the donut shops. After the closing, Dulce ran the donut shops. So there's no direction of the business by North Texas after the closing. It did not happen. The affidavit says it doesn't happen, and no one argues that it happened. Now, it's true.
May I ask, is North Texas the limited partnership, or is it one of the members of a limited partnership when before the purchase?
Well, North Texas was I believe was a limited partnership, and I think that the trial judge went off on some issue about the relationship between North Texas and Krispy Kreme, which was not.
That's kind of what my question is going to be, was North Texas in a limited partnership with Krispy Kreme? Was Krispy Kreme the general partner? And if that is true, was the status of Krispy Kreme being the general partner and now being the franchisor somehow indicative of them maintaining a continuity of control? Not just because they're in a franchise situation, but because they were also part of the business entity from which Dulce acquired the donut shops. Did that put you? Did my question put you to sleep too? It's pretty long.
No, Your Honor. That's. I think it's a good question given what the trial judge did on this kind of bizarre phone call that you'll see referenced. But actually, I don't think your question is relevant, but I'm going to answer it, of course. I'm going to let Mr. Kennedy explain why he thinks the relationship between the seller and Krispy Kreme is relevant and exactly what his argument is. I don't know what his argument is. I will say, though, that there's a letter in the record that Mr. Kennedy wrote to the trial judge that says, the Texas Workforce Commission did not intend to assert continuity of control exercised by Krispy Kreme as an independent ground for summary judgment. So the point you bring up was not in the motions for summary judgment that either side filed. There was a letter that was written that Mr. Kennedy and I agreed to after the very bizarre set of phone calls. Now, that's alluded to in the record, but basically the trial judge came up with this other theory that you've mentioned. I don't really even understand this other theory. I didn't understand it at the time, but I think both sets of counsel understood it had nothing to do with the motions and it wasn't part of the case. So we brought that up in our brief, complaining that it seemed like the trial judge had ruled on the theory, even though it wasn't before the parties, because there was another acquisition here of another donut shop. And there the trial judge agreed with my client. So it was a very bizarre situation, because in the case of the acquisition, the trial judge agreed with my client on and ruled against the TWC. There was almost identical language in the agreement relating to this franchise situation. I think there's some nuancing in the language, which makes absolutely no difference. But I think it's black letter law that in a summary judgment case, the trial judge may come up with some great argument that had he been the lawyer in the case, he thought might be relevant argument. He can't inject that into the case and use that in ruling on the case, and everyone would agree with that. So that asks a level of complexity, which I really had intended to ignore today. And I'm not complaining about the court's question, but I think we have to look at the summary judgment grounds that were pled, that were briefed. And then we have to look at his ruling. And I think Mr. Kennedy argues in his brief that he's not trying to argue anything beyond the summary judgment grounds. I don't know if I've answered your question.
Oh, that's fine. Thank you.
So that's where we are. Now, I disagree, by the way, with the trial judge's focus on the relationship between Krispy Kreme and the selling entity, North Texas, because the statute talks about the predecessor employer having a continuity of control. And Krispy Kreme is not the predecessor employer. And we briefed that in the brief of appellant. So even there, the trial judge went off into something that would have contradicted the wording of the statute. Now, there wasn't some kind of alter ego argument made. You know, if there had been some corporate sham going on where North Texas was the same thing as Krispy Kreme and they didn't follow corporate formalities and there was this corporate sham type of enterprise, had that been pled, well, we'd be talking about it. I don't believe there's any substance to that. I mean, that's a fictional thing I'm mentioning, but that really wasn't the facts at all. I don't know how much time I have left. If I might.
Showing up, you have 12 minutes.
12 minutes. Okay. So let's talk about this theory that the franchise agreements created some continuity of the control on the part of North Texas. Let's really take a deep dive into that. First of all, the law is clear that franchise agreements do not create control on the part of the franchisor over the franchisee. That's covered in appellant's brief toward the end of the brief. That's black letter Texas law. And if you didn't have that law, you would dramatically change the law of products liability, the law of a lot of other areas, because plaintiffs' lawyers come in and say, Krispy Kreme, we're going to sue you because this little donut shop number 325 violated labor laws or racially discriminated or didn't comply with the mask requirement during COVID, whatever the creative theory would be. Well, the franchisor is not running the franchisee. Now, obviously, franchise agreements do have requirements. You know, you've got to have the donuts have to look like donuts. You have to use certain ingredients. There's recipes. You know, we all understand that a franchise relationship is a business deal. But the TWC seems to say that North Texas, by requiring Dulce to follow a franchise agreement, is exercising control over Dulce. First of all, the first problem with that is that franchise agreements don't exercise control in the manner contemplated by the definition that we're talking about, which is in 204.081A3D. Now, that's our first argument. Second, even if I'm wrong, even if you disagreed with me on that point, the control that the putative control that we would be talking about would be controlled by Krispy Kreme. Krispy Kreme, you could argue wrongfully, I think, controls all of its franchisees because Krispy Kreme manages every time they do anything. And that really Krispy Kreme is controlling the franchisee and Dulce is not really running its own business, but Krispy Kreme runs the business. Well,
remind me, Mr. Siegel, if I'm just so I'm clear on the record, though, that what we're dealing with under this franchise agreement, at least on Krispy Kreme's side, is if you don't comply with the agreement, they have the ability to pull the franchise. Is there anything in the record that indicates that Krispy Kreme can control the day-to-day work activities of the employees themselves?
No, no. And obviously, if you blatantly violate a franchise agreement, of course, the agreement could be terminated, but that's something Krispy Kreme can do. In other words, the reference to the franchise agreement in the acquisition agreement between Dulce and North Texas doesn't create any control. The control, if you're saying it's control, is created by the franchise agreement between Krispy Kreme and Dulce. The fact that the agreement references, the fact that the acquisition agreement between Dulce and North Texas references the franchise agreement doesn't create any control on the part of North Texas at all. I mean, if that wasn't in the agreement, Krispy Kreme would have the same rights under the franchise agreement to pull the franchise agreement if Dulce doesn't comply. So franchise agreements, my argument is, you could argue create control of some nature on the part of Krispy Kreme, but the statute is talking about the predecessor employee continuing, and use the words continuing to have control of the day-to-day management. I'm paraphrasing. And that never happened. And so to then start going to the franchise agreement, that's really, it's a flawed view of the world, is my point. And frankly, once the money was paid and the acquisition was done, North Texas had nothing to do with Dulce. I suppose that if, let's come up with a crazy scenario. Dulce decides to blatantly violate their franchise agreement. They disregard Krispy Kreme's franchise agreement. Their donuts are terrible. They abuse their workers. The police are there. Whatever the situation is, they get shut down. Maybe the police shut them down. Who knows? Well, let's say something bad happens. And then they try to turn around and sue North Texas and say, oh, we bought a terrible business. We've lost all this money. Obviously, the point would be made, well, wait a minute, guys, you violated federal law, you violated state law, and you violated your franchise agreement. Why are you suing North Texas to get your money back? So I don't know that that case is a real case, but that would be the case whether the acquisition agreement referenced the franchise agreement or not, because it's common sense when you buy a franchised restaurant, of course, you're going to have a franchise agreement going forward. And of course, you're going to have to comply with that franchise agreement. But that control is going to be exercised, if you're calling it control, by Krispy Kreme. Now, we're saying there isn't any control there that would create anything under the statute. But even if it did, it wouldn't be controlled by the predecessor employer, North Texas. It would be controlled by Krispy Kreme. I mean, who's running the donut shop? Is it Dulce? Is it Krispy Kreme? Is it North Texas? I would say Dulce runs these donut shops, right? And that's what the record is, by the way. You could argue wrongfully that Krispy Kreme is somehow controlling them, which is not true. You could argue that North Texas is running them, which to me is just a fantasy. That's all I have, unless there's any other questions.
You do have six, just by the way, you do have 6 minutes left. Do you see the window up there on the screen, the multi windows is a timer? Is that showing up? It's in red?
I don't see it, and my eyesight's not that good, but I don't see it. But I'm happy to take any questions you have for the remaining 6 minutes. I was trained, if you've made your point, shut up and sit down.
I appreciate that. We appreciate that. Judge Purtle, Judge Dulce?
I'm good.
Thanks, sir. All right. Just a quick question, Mr. Siegel, do you see the panel of judges?
I do. I see Mr. Ramirez, Justice Lawrence, Justice Doss, and Chief Justice Quinn.
Okay, do you see Mr. Kennedy?
I don't, and that may be a fault with our setup on our computer. I don't know if that's our problem here on our end. I'm sure Mr. Kennedy's on the line, though. I hope he is.
He is. No, it's just somebody just said, I'm getting messages, and they said switch to gallery view.
Yeah, there's speaker view and gallery view. And if you're in speaker view, you just see a few of the boxes.
Right. I think that's maybe something that can be formatted differently, but I'd have to get my assistant to come in here and I don't want to be rude.
No problem. Mr. Kennedy, can you see the timer?
Yes, Your Honor.
Okay. The floor is yours.
May it please the court. Dulce Restaurants inherited its predecessor's compensation experience based on the unambiguous terms of the asset purchase agreement and the plain language of the statute. Nothing, no extrinsic evidence can change the asset purchase agreement, nor can any extrinsic sources change the plain language of the statute. Turning first to the statute at issue in this case, transfer of compensation experience is necessary anytime two elements are met. The first element is there's a transfer of all or part of the organization, trade, or business. Now, there's no dispute here that that first element is met. If there were any dispute, the asset purchase agreement definitively shows that. It's the second element that's in dispute here. The second element is about whether there's substantially common management and control or substantially common ownership. Now, TWC transferred the compensation experience based on substantially common management and control, which is a term that's defined by the labor code. And it's defined as existing when one of four things happens, and I won't get into all four because only one of them is relevant here. And the one that's relevant here is the predecessor employing unit continues to direct the internal affairs or conduct of the predecessor of the organization, trade, or business. Now, the asset purchase agreement, the unambiguous terms of the asset purchase agreement shows that North Texas Donuts LP continues to direct the internal affairs and conduct of Dulce's operation of the organization, trade, or business. The provision I'm talking about specifically says, buyer represents, warrants, covenants, and agrees that following closing, buyer, and that's Dulce, will continue to operate the stores in accordance with the terms of the applicable franchise agreements. And that's referring to a new franchise agreement that Dulce will enter with Krispy Kreme Donut Corporation. Now, I think it's important to understand the relationship between the parties here and why this provision's in this contract and not the contract that for the store that's not before the court. North Texas Donuts LP is the predecessor employing unit. It is a limited partnership, and the general partner was Krispy Kreme Donut Corporation. So everything it was doing was controlled by Krispy Kreme Donut Corporation, who is also the franchisor of the Krispy Kreme stores. And so we're not asserting continuity of control per se, but I think the relationship between the parties informs why this clause is in this contract and why it's important that in the sale of the stores that North Texas wants Dulce to continue following the asset purchase or continuing following the franchise agreement following the sale. By way of an example,
You're not arguing continuity per se, but in a way you are. It's because the general partner, Krispy Kreme, directed Dulce to abide by the franchise agreement with Krispy Kreme.
Let me clarify, Your Honor. North Texas Donuts LP entered an asset purchase agreement with Dulce, and North Texas Donuts LP demanded in that agreement as a condition of the sale that Dulce continue to follow the franchise agreement with its general partner. So the control is not coming from Krispy Kreme Donut Corporation. The agreement is between the two parties, the predecessor and the successor. The predecessor is then asking them to comply with an agreement with the third party. And maybe a different example maybe illuminates this. Let's say
But it is coming from the directive of the manager of the seller. And that would be Krispy Kreme, correct?
Sure, but the entity that was entering the contract, the predecessor employing unit was Krispy Kreme, or I'm sorry, was North Texas Donuts LP. So that contractual provision, just because it's managed by North Texas, or I'm sorry, Krispy Kreme Donut Corporation, doesn't mean that the control we're saying the control is coming from them. The control is North Texas Donuts Corporation requiring as a provision of the contract that Dulce follow Krispy Kreme's directives in a second agreement that it effectively incorporated by reference. Now, an example maybe helps clear this up. If I have a football and it's the best football that's ever been made, and I sell that football under a contract to a quarterback in the NFL, and I say, you have to use this football for under NFL rules, otherwise you breach my agreement to sell the football, and I've sold it maybe for less than it's worth because I'm going to get advertising or whatever in the future. And the quarterback likes his football is underinflated and violates NFL rules by underinflating the football. He's violated not only NFL rules, but he's violated my contract that said you have to use this football in accordance with NFL rules. That control is not coming from the NFL. That control is coming from me and the contractual provision that I put into the contract, the condition on the sale that says you have to follow NFL rules. And that's the same situation that we have here. So the franchise agreement is relevant because North Texas Donuts LP made it relevant as a condition of the sale of the Krispy Kreme stores. And I know there's an argument that the franchise agreement doesn't dictate internal control or internal control or direction. That's contrary to the franchise agreements. We have Appendix A that we attached to our brief that lists all the manners of controls. There's 18 different categories and countless different ways that there's control through the franchise agreement. For instance, Dulce can't do anything but operate Krispy Kreme stores. They can only have their business organized in a certain way. They can't change ownership. Where the money goes is dictated by the franchise agreement. The store hours, what is sold, when, where, and how it's sold. So all of that gets back to the provision in the asset purchase agreement that specifically states, following closing, as a condition of North Texas's sale, Dulce has to comply with the franchise agreement it's going to enter.
Mr. Kennedy, I've got one question for you.
Sure.
You made reference to the statute early on, and the way I wrote it down, I thought what you said was that there has to be evidence of substantially common management and control. Is that right?
Substantially common management or control.
Or control. Okay. It's
And yes, and that provision explicitly is defined in the statute. So it's not a plain language interpretation that you're looking for substantially common management or control. You're looking for substantially common management or control is defined as existing if after the acquisition of the organization, trade, or business of an employing unit, the predecessor employing unit continues to, and there's 4 different categories. The one relevant here is direct the internal affairs or conduct of the organization, trade, or business. So the relevant inquiry for this case is, does North Texas Donuts LP continue to direct the internal affairs or conduct of the trade, organization, or business?
And I guess that's the part I'm confused about a little bit. I don't understand how they are presently directing the control other than having the right to seek a suit for a breach or to try to undo the original contract.
Sure, and that is continued control. So if I put conditions on your use of a product, I'm dictating the manner in which you behave with relation to that product. So the same is here. I have sold stores to Dulce, but I have a contractual provision that says you need to use these things in a certain manner. I'm directing the conduct, the behavior of Dulce by requiring them to operate under a franchise agreement under a Krispy Kreme store. So they can't turn around and use the equipment that I just sold them to operate a Dunkin' Donuts if they like Dunkin' Donuts better than Krispy Kreme. That would be a breach of the agreement, and they're just not allowed to do that.
Does it matter whether it's actual control versus ephemeral control? Because North Texas directed them to do something that they were going to be required to do anyway by Krispy Kreme.
Well,
So
they were
it's really not real control. It's a directive, but they're going to do it anyway. They had to do it anyway, irrespective of what North Texas said.
They were going to do it anyway, but at the same time, it wouldn't have any impact on North Texas if it weren't in the agreement. So if they were going to do it anyway, the issue would be between Krispy Kreme Donut Corporation and Dulce. But here, that's not the situation. They also conditioned the sale of the assets on the continued control. So
If
in other words,
by abiding by the franchise agreement, they injure somebody, let's say, and can they sue Krispy Kreme because Krispy Kreme directed that? And can they also sue North Texas because
sorry.
Krispy Kreme, North Texas directed it?
so you're asking in a personal injury, let me just clarify, you're asking in sort of a personal injury context, if there's vicarious liability on Krispy Kreme and North Texas Donuts?
Well, yeah, and don't tell me, oh, the franchise agreement takes care of that. I'm just thinking in general, if there was some type of cause of action that arose vis-a-vis a third party against Krispy Kreme because Krispy Kreme required compliance with the franchise agreement, does that mean they can go after North Texas too because North Texas required compliance with the franchise agreement?
In a hypothetical situation where if they could go after Krispy Kreme Donut Corporation, I think that would be right. They could also go after North Texas Donuts, but I don't think.
Remember that, Mr. Siegel?
I'm sorry?
Remember what he just said. You may be able to go after North Texas too.
Okay.
So I think that also depends though on being able to go after Krispy Kreme Donut Corporation. And I think the vicarious liability laws are very different than what is required by the statute here in terms of the level of control and controlling the act that the employee did to injure the third party. So I think that there's a lot of hypothetical things that would have to happen that I think are very unlikely in even getting to the Krispy Kreme.
Oh, I understand that.
Okay. I want to turn quickly to Dulce's principal argument that the trial court ruled on grounds not raised. It was the principal argument in the briefs. It's black letter law that a final judgment and an order granting summary judgment that don't specify the theory on which it's granted. The appellate courts can affirm on any ground raised by the parties, and the argument that I've just presented is a ground that we raised expressly in the trial court.
Mr. Kennedy, let me ask you a question of something that just came to mind using your example from just a minute ago.
Sure.
And this is a pretty common issue we see in franchise agreements, which is a provision that says that the buyer agrees to comply with all federal and state laws. That's a standard clause that's included in most agreements. Is that retaining the right to control in the position of the TWC?
A provision that says complying with state and local laws.
If the predecessor provides or includes that clause in a franchise agreement that the buyer will comply with all federal and state laws, is the TWC taking the position that evidences the retaining of the right to control?
If the sale were conditioned on that for some reason, and I don't know why you would condition the sale on that in any particular reason, but I think that could potentially, but again, I think that's very speculative based on facts that I can't imagine actually occurring. If you just generally say you have to comply with federal and state laws, I don't think that meets the threshold. I think
what is the difference then in this franchise agreement between that hypothetical and the situation we're dealing with now, except for the fact that rather than dealing with a set of laws or statutes that we're complying with the franchise agreement that a third party has?
Sure. So North Texas Donuts LP has an interest in Dulce continuing to operate under the franchise agreement. So they probably in all likelihood didn't sell this equipment at what the market rate would be because their parent company, the general partner, was going to get additional compensation on the back end of the transaction. So there's a situation where there's an interest in the continued operation a certain way by North Texas Donuts LP, whereas there generally isn't going to be an interest in John Q. Public, or even take the other store that's at issue in this case, where there was a separate franchisor that wasn't owned by Krispy Kreme, the parent company. They have no interest in whether or not Dulce continues to operate that store in accordance to the franchise agreement. It doesn't matter to them. So I think that's the crucial distinction here, and why this term is in the asset purchase agreement, and why it's important to North Texas for Dulce to continue that operations under the terms of the franchise agreement. And I think turning to the evidence that Dulce cites that says, this doesn't evidence control, that's all extrinsic evidence based on the affidavit of an interested witness, the general counsel for an entity that provides legal services. And then I just briefly want to address one other point that was in the reply brief that Dulce filed. They wanted the court to look to legislative history instead of the plain language of the statute. And they cited to the Code Construction Act, saying that the court should do so. The Code Construction Act does permit courts to do that, but the Supreme Court has stated when the language of the statute is plain and unambiguous, the inquiry is at an end there. And to the extent that the Code Construction Act says anything different, that's simply unconstitutional based on separation of powers. It's the court's duty to determine how to construe statutes. So unless the court has any other questions for me, I'll cede the remainder of my time and ask that the court affirm the trial court's judgment.
Thank you, counsel.
Thank you.
Mr. Siegel, you have 5 minutes for both.
Thank you. I just want to pick up on Justice Dawes's question about what if the acquisition agreement said you have to comply with all federal and state law. Well, here, it's really the same situation with a franchise agreement because it says you have to enter into a franchise agreement with Krispy Kreme. It's up to Krispy Kreme to then renegotiate a new agreement with Dulce, which is what happens. So Krispy Kreme determines the content of that franchise agreement, not North Texas. Moreover, these franchise agreements give the franchisor certain rights. For example, they can change the opening hours. They can change a lot of things. If you look at the franchise agreement, Krispy Kreme has the ability to tweak different things and North Texas has nothing to do with that. So I think the other point here is there's a case called the G&A outsourcing case, which we've cited. G&A outsourcing, I think, is helpful because it involves very similar arguments. And the trial judge in that case got reversed. And in G&A outsourcing, the TWC tried to make the same sorts of arguments. They said, well, there are these other collateral agreements with other parties. And so that means that there's a continuity of ownership of the assets. And it actually deals with other parts of the definition. But I think that the logic or reasoning of G&A outsourcing applies here. Also in G&A outsourcing, they do focus on the purpose of this statute. Legislative purpose of a statute is something that definitely can be considered under the Code Construction Act. In fact, they did that in G&A outsourcing. Here you have an arm's length agreement between North Texas and Dulce. This was not set up to try to get around a bad employment compensation rating. That's not alleged. So whatever the arguments are being made here are not reasons why the rating experience should be transferred. There's nothing that was done in the acquisition agreement, the structuring, anything that suggests that the continuity of control definition should apply. I don't think the definition, by the way, is as clear as the TWC says. It talks about the predecessor employer unit continues to. Well, what is continuing here? There's no continuation of the prior control. It's a new kind of control they're arguing because the donut shops were being run by North Texas. They're not running them anymore. There's some new control created by the franchise agreement. So it really violates the word continues. Then it talks about direct the internal affairs or conduct of the organization, trade, or business. Direct the internal affairs. To me, that implies you're going to be directing it. Okay, not having some incidental influence on it. I mean, if anybody's directing the internal affairs of this business, it's Dulce. If you don't agree with me on that, then you would say, well, Krispy Kreme has a lot of impact on the direction of the business. North Texas has no impact on the ongoing direction of the business. Continue to direct. It's talking about a post-closing direction that should be continuing what was done pre-closing. That's a textual analysis of that statute that I believe is an appropriate reading of it. Here, post-closing, there's no direction of any kind, let alone the direction that occurred prior to closing by North Texas. And the idea of direct, the internal affairs or conduct of, I think implies or indicates that North Texas would continue to direct it. Why am I saying that? Because this whole statute was designed to deal with a very special problem. Company has a bad rating. They come up with a creative restructuring. Hey, let's have my mother-in-law buy the business, or let's set up a subsidiary, or let's have different tiered partnerships where there's some new separate entity that owns the business, but we still control it. This is not that kind of creative structuring in any way, shape, or form. So to somehow superimpose this structure on these definitions is not reasonable. And it really is a bad and improper statutory construction. Why? Well, that's what G&A outsourcing really says, because they look at the purpose behind this anti-SUT statute. And we do cite the legislative history, because when this statute was amended in 2015, in the legislative history, the legislature went out of their way to talk about the fact that franchise agreements shouldn't be involved, shouldn't have a role in the application of the statute. Now, that was in connection with changes to the statute that had nothing to do with this case or the dispute in this case. So it's not like they changed it, the statute. They kept the statute, but they clarified in 2015 that the TWC's position is wrong. That can be considered. And I just disagree with that. Thank you very much for your careful attention.
Questions? Thank you, Council. We appreciate your willingness to attend by video conference, and your case is submitted, and you are excused to return to what you were doing. And we will be in recess until our next case this afternoon. Again, thank you very much.
Thank
Thank you,
you.
gentlemen.
Thank you.
Thanks.